The jury nullification issues cuts both ways, and it can be a good thing and it can be a bad thing. Let's look at the history of some of the bigger cases or more well-known cases where it's been used. One of them is with the Prohibition and people who were charged with violating the Prohibition Act.
I think that's what stopped Prohibition.
It is one of the factors that came into stopping it. Another one was the fugitive law issues, and especially in northern juries, sort of using jury nullification to say someone who harbors a fugitive slave, we're not going to prosecute under this law. Our founding fathers sort of used jury nullification in their attempt, when they put it in the Bill of Rights, that you have a right to a trial by a jury.
Of your peers?
Of your peers, as another defense against laws that shouldn't have been passed in the first place. You know, you have the House that has to pass it, the Senate, the President has to sign it, judges can review the law and determine whether it's constitutional or not, and a jury doesn't have to apply it if they don't want. But on the other hand, when we had civil rights violations and people who were killed in the South trying to express their civil rights or other people's civil rights, juries wouldn't convict despite massive amounts of evidence of someone being guilty of murder. So it cuts both ways.
And of course that was the O.J. Simpson issue about how many black people might have said, for all those years, this is our comeuppance, this is the
other side of that issue.
Yes. There's an opportunity to vote in a ballot box. There's an opportunity to vote as a member of a regular jury. What's the difference between a regular jury and what we know as a grand jury and those who can, what do they say, indict a ham sandwich?
All right.
Well, a grand jury is an investigatory tool, investigative tool that's done by using the U.S. Attorney and Federal
Court. Or the Attorney General.
Or the Attorney General.
Right.
You're not hearing the defendant present his case. As a matter of fact, the defendant can't even be a part of that case. The defense attorney can attend.
Right.
But all you're hearing is the prosecution's case. The grand jury's responsibility is to determine whether or not there's enough evidence to issue an indictment. So is this person going to be charged? If they issue the indictment, then you have a formal charge. But with a regular jury, you're actually hearing the case in its entirety. The defendant is present. You're hearing the defendant's attorney present witnesses, cross-examine witnesses. You're hearing both sides.
So the grand jury is, in the criminal world, there's different ways that someone can be charged with a crime. The Attorney General can bring evidence to the grand jury for them to determine whether or not they think there's a crime that's been committed, and then the grand jury hands down an indictment. That's one way you can be charged. Other crimes, less capital type crimes, lower type of crimes, and even some, felonies, the Attorney General can just sign an information. That's a complaint to the court saying, on my information and belief, this crime has been committed, and the person can be charged based on that information. So the grand jury is used by the Attorney General in cases where he wants to do some investigation, issue subpoenas, bring people in, find out what they're going to say before the charges are brought against whoever is being charged.
So is that where the idea of indicting a ham sandwich is so common that it doesn't
you're not hearing the defense
You're
side.
Not hearing the rest of the story.
You're only hearing one side of the story.
Exactly.
And I've been told that it's also an idea of how you protect the public from an overzealous prosecutor, and I'm sure that there are many who think that they have a good reason to prosecute a case or bring one to trial. Checks and balances?
In some way,
In some
I like to
ways.
think it is, yeah.
Right. Although, as you say, and as Jackie and you have pointed out, they only hear from the Attorney General. So if they have a good relationship with the Attorney General who's bringing the case, because usually the same Attorney General works with a grand jury that sits for a fair length of time. It's not like this 2-week or 2-day period that the petit jury sits for. That's the jury that hears your case. So they can develop a relationship and have some trust of him. So if he says it, they believe it, they indict.
Would this then speak to yet another good reason why, if you had a professional jury, they would have more of a sense or sensibility about whether or not something really should come to trial, because they would have been through it enough times to sift through and have a greater power of discernment and not tie up our court systems? Is
So
there
you're saying professional people that have served previously or not
Served
highly
previous-
educated?
On a grand jury?
served previously on a grand
Highly
jury,
educated.
understand, have the power of discernment that you addressed? It might have fewer cases to be prosecuted, but they certainly might have greater validity if you,
Yeah,
instead
don't
of
want that.
ham sandwich?
You don't want that because it could go the other
You
way.
could go the other way. Sometimes you don't want somebody to overanalyze the
Right.
case either.
And if a group of people is sitting there for a period of time and now they're just another political process perhaps, or how do you get on this jury? Why are you picked for
Yes.
it? You know,
Yes.
the system we have just takes people through everyday ordinary people, and that's the whole idea. You want your peers, you want the everyday ordinary people who are not there appointed or whatever other means that you might
Or
create
jaded,
this, or jaded, who are bringing their own sense of the community and their responsibility to that hearing.
If there were such a thing as and in, I guess, some countries there are professional jurors, does that open up an issue of there being legal suits against a professional jury for not having done their duty properly, and could they then end up having some litigation waged? I mean, does that end up opening that?
I think there's a
That is a
potential
can of
for
worms.
it,
Yeah,
sure.
it's definitely got some potential. Although there is judicial immunity for judges, there's immunity for jurors. It's the system's currently set up. The system works. Now, you might suggest, for example, that didn't work in the Casey Anthony case. Well, we didn't sit there and listen to all the evidence they listened to. Remember, the government bears the burden of proving its case. I didn't listen to that testimony. I don't know what went on in that case, but I believe that if this jury sat there and listened to everything that they listened to, they may in their hearts believe that she committed a crime. But if they don't feel the government proved its case, then they did the right thing.
Do you want to weigh in on that as well?
I agree. I didn't follow the case. What I do think is that she was overcharged, and by that I mean they should have charged her with a lesser offense. And
Such as?
Maybe negligent homicide or
Right.
How about child abuse? Oh, that would have been too low.
that would have been too low. So
Okay.
there you go with the political process again, because
Right.
that affect what they charged her with is going to affect what
It's
they-
going to reflect back on
On
the
them.
attorney general or district attorney or whatever they have in Florida.
What David said is correct. I believe that what they heard wasn't sufficient enough for a finding of guilty based upon that particular charge.
Right.
The exit interviews, such as they were,
They didn't happen.
ended up
Only a couple.
and only a few ended up speaking.
Yeah.
But the ones who did said that they were heartsick about what happened, but they also felt that when they were charged with judging only on the facts, that they said in many cases, we believe that she's not innocent, but when we were asked to weigh these facts that the case that was presented in the case, they didn't add up to where it happened, when it happened, how did she do it, and there wasn't sufficient evidence, and that in itself ends up meaning that she can't be charged with
Or that the
Guilty.
government didn't sustain its burden of proof.
That's right.
Because they could have circumstantial evidence, they could have some belief, but that jury wanted some proof. You know, what does beyond a reasonable doubt mean? It means something, and they didn't feel the government sustained that burden.
But here again, if they all sit around in their jury deliberation rooms and say, who else? It has to be. It makes so much sense. Maybe their common sense or their sensibility says, it had to be her.
Yeah, but they're not there to speculate.
And that's what they say. They're not there to speculate, but that's a jury nullification thing.
It is, in and of itself it is. They're not there
Well,
to speculate.
Jury nullification is, did
The law wasn't-
they say the law wasn't right as
law
it
wasn't
applied?
right?
Here is the facts. And so they're saying, you're asking us to determine the facts to sustain this charge of first-degree murder, punishable by death. And what they're saying is the government has to bear its meet its burden of proving that she did what she did, because if we find that they did, she could be put to death in Florida. And so we're not going to convict her based on what evidence was presented to us, as you said, with all these loose ends, without knowing anything as to what really happened here. So if you want to bring that kind of charge, bring it with evidence that will meet that burden, so that if we do convict someone and they now are subject to the death penalty, we have done our job right. So all they were doing was making findings of fact and saying, you didn't bring us enough facts to sustain your burden.
I mean, I certainly understand why they would say we can't convict on her bad behavior, which was, I don't know, what mother goes out and parties after the
Right.
child's missing or presumably dead. But in hindsight, you can do Monday morning quarterbacking. Now, you as the prosecutor, you know you can't tie her with so many facts to that crime. Does that mean that they actually should have tried to say that there was another offense rather than first-degree premeditated murder? Is that what you would have done?
Monday morning quarterbacking.
Yes, go ahead.
I
You can do that
honestly,
here.
as I said before, I personally feel that they overcharged her, okay, because of the public outcry as to what happened. I think a lot of it had to do with it being sensationalized because of certain TV reporters. And so once that reporter latched onto it, it was all over the country. It was there 24/7. You heard about this constantly. And then now it's sensationalized. And maybe because of that, she was charged with, you know, a capital offense and death resulting. But I wasn't there. I don't know what evidence they had. I think they probably should have.
Again, I didn't follow it closely enough to be able to tell you what they should have charged her with, but from the little I know and the feedback afterwards, certainly there was enough that they had to charge her with child neglect or abuse or something of that nature.
Certainly.
And certainly in Rhode Island we have some statutes that also lead to murder-type charges or negligent homicide-type charges based on what she did. And I do believe that a jury, now knowing that the death penalty is not in play, probably would have listened under the circumstantial evidence they had a lot closer to that and made the findings of fact necessary to show that the government proved that type of case.
I also think if she had testified, you would have seen a different result.
Oh, she would have been
How
convicted.
so?
She would have been convicted.
Because?
Because she was proven to falsify evidence, make false statements. False police report.
Right. She had too many different
There are
stories.
too many different stories, inconsistencies.
Okay.
I don't think she would have been a good witness.
Right. And now the jury...
That's bad behavior, but that doesn't say
Well,
that
but the
she
juries now,
did that to her child.
juries don't like people who get up in front of them and lie. So whether or not it would have been enough to tip it over, to give her, them enough reason to now say, oh, she clearly can't tell the truth and we're going to convict her because now we don't like her, I can't tell you for sure, but I think Jackie's right, it probably would have.
Plus, she's subject to cross-examination.
Right.
She's subject to cross.
One other question, quickly, and it's a little bit of cynicism here. If they had said that she was guilty, where's the book in that? However, saying that she's not guilty, does that certainly means that every one of those jurors, or some group of them, or a few of them, are likely to be able to write a book about how they felt, what they discussed, how they discussed it, and why they came there. Should that be allowed?
I don't think it should be allowed.
No.
But then you have an issue with free speech, and how
Right.
can you prevent that?
Right.
If she had been convicted, then you have an issue there. If she writes a book, that she's not
For her.
able, for her as the defendant, she can't profit from it.
Yes, but
The jurors.
as far as the jurors go, I'm not so sure from a public interest version of what a juror has to say in a book is all that interesting. From a legal standpoint, it would be very interesting for lawyers to know what went into their decision-making process.
And future lawyers as well, I imagine.
Exactly.
Yeah.
Yeah.
Interesting. We hope that this has been helpful to you, helpful if you do end up having an opportunity to serve your civic and community duty. I understand that there is at the Rhode Island Bar Association, and I assume at the Massachusetts Bar Association too, RIBAR.com, there's additional information about serving on jury duty and how to do it. We do hope that this has been helpful to you, and we thank you for tuning in. I hope that you'll continue to tune in and watch that the next chapter, the next installation. I wonder if bad law is a law until the Congress ends up overturning it.
Or a jury.
Or a jury.
Or a judge.
Stay tuned. Our discussion of legal matters continues.